It's Wednesday. We love Wednesdays. It's Wednesdays, one of our last opportunities for this year. Good morning. Thank you for coming. Our last opportunity to learn about civil procedure. But first, what's happening in your legal universe? Well, criminal procedure, because old habits die hard, and I can't just talk about civil procedure here. We have to wade into criminal procedure a little bit. And one of the fun things about criminal procedure, vis-a-vis the media, is that the media seems to think that the filing of a notice of appeal is always a newsworthy event. It's really not. As we'll see later on today, a notice of appeal is really not that big of a deal unless you screw it up, and it doesn't really big deal. Right? The notice of appeal in a criminal case, not a big story. You pretty much expect these criminal cases to be appealed. You pretty much expect any case to be appealed at least once, because you have a matter of right appeal almost every place you go. Let's ask, though, what do you think about this? For those of you, is anybody think criminal procedure this semester? So, Civ Pro people. Not a shocking thing that she appeals her murder conviction. Anybody would or should appeal a murder conviction. In fact, if her attorneys hadn't filed this notice of appeal on her murder conviction, it would probably be malpractice. What if she had won? What if she was acquitted? Could the state appeal the acquittal? No, everybody's shaking their heads no. Good. So we know this already, right? The state can't appeal an acquittal. Why not? Right? Yeah. Double jeopardy? Double jeopardy contained in the Constitution? Is there a particular provision in the Constitution? Double jeopardy clause found in the Bill of Rights. Maybe something in the book. Yeah, it would violate the double jeopardy provision of the United States Constitution because you can't put somebody on trial for the same crime twice. Okay. Right. That's right. That's a more advanced part of the Constitution. All right, so appeals. I love appeals. Appeals are my jam. I love them. So much fun. So much more fun, in fact, than the Erie Doctrine, as you'll see. That's just one man's opinion. But when we talk about appeals, we're really talking about finality. That's the first threshold that we have to cross here. Okay? I know you had a lot of reading. I'm going to try to distill it down to just a few coherent, memorizable points. Okay? The final order is only the only thing that can be a final order. Because it can be hard to discern what a final order is. Okay? But the only thing that can be a final order is something that fully and finally adjudicates all the rights and the liabilities of the party. Okay? So it takes care of everything. Little asterisk by everything. But it takes care of everything. We've made a decision on all the claims that were brought in the complaint. We've determined that all the defendants are either liable or not liable. Then that's a final order. Now, oftentimes, actually, judges will do this helpful thing. I'll come back to this slide again. But they'll do this helpful thing of saying, this is a final and appealable order. Have you seen this? Those who have worked over the summer? Have you seen this all the time? This is a final and appealable order. There's no just cause delay. It's in the order of execution. Which, in this case, motion for summary judgment against the plaintiff is granted. All claims by the plaintiff against the defendant are dismissed. This is a real order executed by Judge Bissett. Okay. She says this is a final and appealable order. And that seems to be right. However, that is boilerplate language, and judges will sometimes put it on non-final orders. Okay. That's why you get paid upwards of $300 an hour to do what you do. Because really, you got to make the determination as to whether or not this is really a final and appealable order. Let's think about this for a minute. 8 days after an order like this is issued, I file a motion to reconsider the grant of summary judgment. I don't think I actually did that, but let's say it. Right? I file a motion to reconsider. Is this order still final? Who says yes? Yes, it's still final and my time for appeal is starting to run. Nobody says yes. Who says no, it's not final? Many of you are too cowardly to make a decision. Yeah, that renders the order non-final. Okay? Until the judge rules on the motion to reconsider, you bought yourself a little bit of time. Because all the rights have not been fully adjudicated.
But that one was final, right?
That one was final appeal, right? That one was final appeal. Sometimes judges will just stick that boilerplate onto any old order. And it's not really final and appealable. It's your job as the advocate to determine whether or not is this a final order. Ask, is there anything left to be litigated here? Are there any claims by any plaintiff remaining against any defendant? If there are any claims against any plaintiff left remaining against any defendant, probably not a final order. Which adds to the confusion of things. 54B says, well, sometimes the trial judge can make an order that looks not final and actually fine. So if you have more than one defendant, and the judge disposes of all the claims against one defendant, 54B seems to suggest that the judge can then say, well, there's enough here and this is sufficiently different from the rest of the case that this is final and appealable and you can go ahead and appeal. Practice that rarely happens. Don't get caught on the wheels of 54B too much. You're not going to use it that much. Okay? Main thing to ask yourself is, are there any claims by any plaintiff remaining against any defendant, and if so, probably not a final. So the bullet breaks it down in what I think is a pretty handy way. Gives you a bunch of examples. Grant for a motion for a new trial based on the weight of evidence. Not a final judgment. We talked about that before, right? Just because the trial is over with, just because the jury has rendered a verdict, that doesn't mean there's a final judgment in a case. So step away from that mode of thinking. In fact, usually, the simple fact that a jury has rendered a verdict in a civil case does not mean that there's a final judgment. You've usually got a lot more to go after that before there is a final judgment. That's why the jury verdict forms don't say this is a final and appealable order and there's no just cause for delay. The final judgment is something that the judge has to sign off on what the jury does. The judge has to say at the end of the day, this is a final and appealable order. Everything is done here. We have nothing more to consider. Welcome. Thank you so much for joining us. Nice of you to be here. So, the trial happens, the trial is over with. I'm pissed at the result. I file a motion for a new trial. The judge says, yeah, actually, I don't think you should have lost this case, so I'm going to give you a new trial. Are there any claims by any plaintiff remaining to be adjudicated against any defendant? Yes. Therefore, the order is not final, therefore, it's not appealable. Can you go running to the Court of Appeals anyway? Yes, we'll talk about that in a minute. Generally speaking, you don't have a matter of right appeal in that situation. Second situation, denial of post-judgment motion for a new trial based on a procedural error. So in other words, trial's all the way over with. I think it would probably be better if it said it could be a final judgment. Trial's all the way over with. I say, that trial really sucks for me, and I'm going to ask for a new trial. But at the same time, realistically, this is how this works out. I ask for a JNOB, or a motion to alter amend the vacant. Make all of my post-trial motions. Say, I really want a new trial, at least here, Judge. The judge says, no, you don't get a new trial. The judgment, as rendered by the jury, stands. And that's a final judgment. And that's appealable. That make sense? Questions about that? We're okay, right? Simple enough. Grant or denial of a motion to certify a case of the class action is not a final judgment. That's true. If you did your reading, you know there's a special rule that allows you to ask the appellate court to review the grant or denial of certification of a class action. So what does that mean? I have a class of prisoners who have been denied bedding. I've identified 200 inmates of this facility that have been denied bedding, just making them sleep on the floor for the last 6 months. I filed a lawsuit. I asked the court to certify the class of inmates. The court says, yes, that's clearly an Eighth Amendment violation, so we're going to certify your class. All the class requirements have been met. You get to go forward with your class action. Then it says, hold on a minute. I don't like that. Now, we don't have a final judgment here. Right? So just said you get to go forward with your class action. You don't have anything even approaching a final judgment yet. But 23F allows you to ask the appellate court, hey, would you review this grant of certification on this class action? We don't think that this should be able to go forward with this class action, and we think that all 200 of these prisoners want to litigate their claims to division. It's not a final judgment. Dismissal of all claims in a case for lack of subject matter jurisdiction is a final judgment, of course. It's dismissal of all claims. Are there any claims left by any plaintiff against any defendant? No. Something less than that, dismissal of fewer than all claims, or dismissal of something fewer than all the parties, in the case of not a final judgment. No matter what. Right? So if I have 2 defendants in a case, one files a motion to dismiss right off the bat, the other one doesn't file anything, the other one files an answer. Judge grants the motion to dismiss on behalf of the first defendant. Can I then appeal that granting of the motion to dismiss, assuming that discovery still continues against the other defendant? No. No, typically no. Okay? That's not a final order. You mean you have to wait all the way through 2 years of litigation to appeal the ruling on that horrible ruling that the judge rendered on the motion to dismiss right at the beginning of the case that got rid of this other defendant entirely? You need a final order on everything before you appeal that? Yes. Typically speaking, the answer is yes. Yeah. We're getting there. The basics of this make sense to everybody though so far? Interlocutory appeals. Precedent. You knew what was coming. Somehow. Some orders can be removed even if they're non-final. What kind of orders? Well, do your research. In each case. But if you look at 28 U.S.C. 1292, that's a pretty good example. This one I think is probably more important, or at least it's been more important in my career than what might lead you to believe and run into lots of litigating over this particular statutory provision. Again, 28 U.S.C. 1292. Interlocutory. By interlocutory, all interlocutory means, by the way, is just non-final. What is going on here? Okay? This means it's not a final order. So the judge issues an order on discovery. The judge issues an order dismissing one party, and one party gets to stay in. These are interlocutory orders because they're not final orders. Basically, anything's not a non-final order, of course, is going to be an interlocutory. And when can you appeal an interlocutory? Well, the big exceptions in the federal system are contained here. Right? Can somebody give me a plain English for A1? Here's read this statute. Well, that's a lot of words, right? Translate A1 for me in plain English. When can you appeal an interlocutory order of the court? What does A1 tell you about that? injunctions. Injunctive relief, right? What's injunctive relief?
Court stuff.
Right. I sue a prison over prison conditions for 5 inmates. Forget about the class action stuff. I represent 5 people who have been denied vetting for the last 6 months. Say, court, not only should we prevail on the merits and have a trial about how much money my clients are owed for this egregious violation of their constitutional rights, but also I'm entitled to preliminary injunctive relief, right? Injunctive relief in the form of order the prison to give them proper vetting. That's injunctive relief. The court can tell the prison to do some affirmative thing, right? Or to stop doing some awful thing. The court says, all right, I'm going to grant your motion for preliminary injunctive relief. I'm going to give you an injunction against the prison. Prison provide vetting to these 5 inmates. That's immediately appealable. You can immediately run to the Court of Appeals over a grant of injunctive relief. Okay. The court says, no, you don't get your preliminary injunction. That's immediately appealable. Okay. So injunctive relief is different. It changes the ballgame. And in cases involving lots of requests for injunctive relief, you can kind of get into a procedural tangle because of that. It's one of the few instances in which the trial court retains jurisdiction over the case, but the appellate court also has jurisdiction at the same time. Usually it's one or the other. We'll talk about that later. Usually you just have appellate court jursdiction or trial court jurisdiction, one or the other. In cases of interlocutory relief, in the case of an interlocutory appeal, injunctive relief, it changes this. They both have jurisdiction. If you look at 28 U.S.C. 1292B, I'll just give you the plain English on that. If you've litigated, so let's say the defendant thinks that the whole case turns on the First Amendment. I've sued the defendant for defamation. They say the First Amendment is an absolute bar. They make a motion to dismiss. Remember the Walker case? They make a motion to dismiss. The judge says, nope, we're going to go ahead with this litigation. And I'm still pretty convinced that the First Amendment is an absolute bar to the plaintiff's claims. So I say, all due respect, Judge, I think you should certify this case under 28 U.S.C. 1292B to the Court of Appeals. Let me take a crack at the Court of Appeals so they can say whether or not the First Amendment is an absolute bar of this case. Love you, Judge, but I think you got it wrong. And I want to check with your bosses. Right? I want to check with the higher court. And the trial judge at that point has the discretion to say yes or no. The trial judge says no, I'm not going to let the appellate court do this. That's the end of the story. You keep going to litigation. The trial court says yes. Then the appellate court has to say yes, we want to hear this, or no, we don't. So there's a dual discretionary function that's going on here. The trial court has to say it's okay for you to seek an appeal. And the appellate court says, yeah, we actually want to hear this. That's 28 U.S.C. 1292B. 28 U.S.C. 1292A, that's injunctive relief, and you get to go there no matter what. Which gives you some pretty stupid results. And you see, I'll give you an example here. You can see how, if litigants were allowed to appeal all interlocutory orders, it has some real chaos. You guys remember the Ken Davis case?
Yeah.
Well, there still is no final order in that case. It's been going on for about 4 years now, believe it or not. But it's final enough. I can talk about it here. When we first got into that, not. It was filed as April Miller versus Ken Davis. April Miller et al. Versus Ken Davis. We asked for a preliminary injunction, that's the PI that's over here. Preliminary injunction from the district court, stopping her from, this is so bizarre way to say it, but this is kind of the way we had to think about it. Stopping her from imposing her policy on the Rowan County Clerk's office of not issuing marriage licenses, right? So we're asking the trial court, stop her from doing this bad thing that she's doing. She's refused to issue marriage licenses to anybody in the county. That's an application of her responsibilities as a county clerk. Make her stop. Make her start issuing licenses. The court says, okay, we're going to give you your injunctive relief. Okay. So then Ken Davis immediately appeals the grant, that's the very top one, immediately appeals the grant of that injunctive relief to the Sixth Circuit. That's 68 up the top, right? At the same time, they ask for a motion to stay, the defendant asked for a motion to stay, Ken Davis asked for a motion to stay the preliminary injunction. So in other words, put this preliminary injunction on pause while we figure out everything else that's going on in this case. The trial court says, no, I'm not going to do this. So they file another appeal up to the Sixth Circuit. So now we have 2 of them going on at the same time, while the trial court retains jurisdiction over the underlying action. Everybody with me so far? She ignores the preliminary injunction, gets thrown in jail. Right? The court holds her in contempt. Finding of contempt is immediately appealable to the Sixth Circuit, so she appeals it up to the Sixth Circuit again. Now we have 3 cases in the Sixth Circuit Court of Appeals, one of which actually has already gone on to the Supreme Court. Okay. At the same time, the trial court action is still going.
This was
No, SCOTUS of the U.S.
sorry.
No, Supreme, this is all federal court stuff, so it goes up to the Supreme Court. I don't know what SCOTUS of At the same time, Ken Davis files another action in the same court against Governor Beshear. There used to be a Governor Beshear. In that case, Davis versus Beshear, they asked for a preliminary. Kim Davis asked for preliminary injunctive relief to keep the governor from enforcing. See if I get this right. To keep the governor from enforcing the statute that requires her to do her job against her. Got that? There's my right. That preliminary injunctive relief request is, of course, denied, and then they appeal that up to the Sixth Circuit Court of Appeals. So we have 4 different actions going on at the same time, Sixth Circuit Court of Appeals, while the trial court action is going on, and actually one goes all the way up to the United States. Yes?
So, I obviously think the case is busy, but that being said,
I have no comment on that.
but if you had been her attorney, what would you have done?
I would have been looking for a new line of work. That is a thorny question. In what situation? If I find her attorney, what would I do?
I mean, like, obviously this doesn't affect chaotic, but
Yeah.
what would other options be for her?
Litigate the case. Litigate the case. I mean, it just depends on what your goals are with litigation on that. If the goals are to create as much chaos and therefore as many PR opportunities as possible, which may be a cynical take on things, but if that were your goals, right? Then why not file everything that you can possibly file? Right? This also puts pressure on all this stuff going on up here, even though we want every single one. It does put pressure on not only the plaintiff, but then has to respond to everything. So it could be a question, it's just going to be a war of attrition in some ways. The likelihood that you're going to screw something up if you're working with a skeleton crew versus a 20-person defense team, not necessarily that's what you have. That's a consideration, but also puts pressure on the court. You know, keeps pressure on the trial court. Because the trial court is then under this appellate court microscope for the entirety, not only that, under a medium microscope in that case, for the entirety of the action. Yes?
So when she sues Bashir, does the state pay the legal fees on both sides of it?
On both sides of it? What do you mean?
Well, because I read like the courier that they said that the state is paying for legal fees for like these actions. I wondered if that one, if Bashir's the governor.
So in this one, no, I think the answer is no. The lawsuit that she filed, because, so they're not paying the freight for her, somebody else is paying that, right? They're probably getting that for a while. For Bashir, she has to have a judgment for those legal fees to pay, so she never got a judgment against the state. Does that make sense? Does that answer your question?
Kind of. So in the top graph thing,
Yep.
the state is taking on the current fees, right? Like.
Yes.
Okay.
Although that has yet to be completely done. But yes. All right, so jurisdictional stuff, we already touched on it. The appellate court doesn't usually, and we've seen some exceptions, but usually the appellate court doesn't have jurisdiction over the action until there's a final judgment. And then there's a brief window that they're going to have jurisdiction over the thing versus a filing your notice of appeal. Okay? This is important for the discussion that we're about to have about properly filing your notice of appeal. Okay? You've got this 30-day window during which the appellate court can take jurisdiction. Now, generally speaking, as we talked about, and this is jurisdictional stuff that matters, because generally speaking, as we talked about here many times, these time limits in a civil case are pretty flexible. You can ask the court for more time, right? You can modify time limits, you can file things out of time. Not so with your notice of appeal. And why? Well, the case law tells us that it's jurisdictional. So if you go 31 days, you haven't filed your notice of appeal, in 31 days from a final order, you haven't filed your notice of appeal. You really don't. The appellate court can't take jurisdiction of it. The trial court no longer has jurisdiction of that. Does that make sense? Simple enough, right? Think about it on the other side of the equation. If you have a non-final order, you file a notice of appeal on that non-final order, what's the other side going to say? Think about this. You're defending a case. I'm the plaintiff. And you win at trial. And the day after the jury verdict, I file a notice of appeal. Because I wasn't paying attention to the civil proceeding class, and I don't understand I have to wait for a final judgment. So before all the post-trial motions and everything else can play out, I just run to the appellate court, I file my notice of appeal. And say, look, at this terrible result that the jury returned, please fix it. What is your response? What do you think? Appellate court doesn't have jurisdiction over that. How do you deal with that? How procedurally do you deal with that? That's a really fun question. If I file my notice of appeal, is the appellate court, it's a non-final order, is the appellate court going to generate a case number for me? Yeah. No. Most likely. And then maybe the court looks at it and says, oh, this wasn't a final order, let's get rid of this thing. But probably not. Probably, you're going to have to file a motion to dismiss the appeal in the appellate court for lack of jurisdiction. Okay. Everybody see that?
If you don't, like,
What?
if you don't, what?
Well, then you get to keep litigating the appeal. Won't that be fun? You don't have to file a motion to dismiss, you can argue in the briefs. This is a non-final order and the court doesn't have jurisdiction. Yeah. Subject matter jurisdiction can be raised anytime, remember?
So in federal court, I was just looking back, so you have 28 days after the judgment to do the post-trial. So you have to generally wait until day 29 to file an appeal.
Depends on how busy you are. Question is, how long do you wait to file your notice of appeal versus your post? I mean, if those post-judgment motions have been filed, then you don't have a final order anymore.
Yeah.
Right? That affects the finality of the orders.
You have to just wait to see if the other side can do it in 20 days. I guess that's what I'm
No. No, but I mean, think about how that plays out practically. If you won a trial, you either know that you need to make some motions to amend the judgment in some way.
Oh, okay.
Right? You know what I'm saying? Or you're, but then you don't need to worry about appealing it. You don't care, right? What else do I want to say about that? What's the problem? We talked about 23F already. You can ask for an appeal, class action certification, 23F. You you the right to go to the appellate court and say, hey, please review this class action certification. The appellate court doesn't have to do it. Writ of prohibition, writ of mandamus. Don't go into practice thinking that you can use these devices all the time. They use sparingly and they are rarely granted. Writ of prohibition is stop doing this bad thing that you're doing, trial court. You're asking the appellate court to say stop doing the bad thing. Writ of mandamus is appellate court, please tell the trial court to do something it should be doing. So the example I give here, plaintiff requests a jury trial, is clearly entitled to one. Trial court says, nope, I don't want to give you a jury trial. We're just going to keep right on litigating this thing for a while. I'm also not going to give you a final order. What do you think about that? You go to the appellate court and you request a what? What? Mandamus, writ of mandamus. Tell the trial court to do this thing. Right? Mandate. It's mandatory. It's mandatory on the trial court to do the thing, to hold the jury trial. Second example, plaintiff requests a jury trial, is clearly not entitled to one. Trial court says, sure, let's have a trial. Could this happen in jury trial? Sometimes these are only bench trial type actions. Trial court schedules a jury trial. In that situation, you file a writ of prohibition with the Court of Appeals, saying stop. Stop that jury trial. Okay. Just know about that procedural device, but then don't ever use it. Right. Problems? In your supplement, page 20, or PDF page 26. What do we think about these? Plaintiffs and defendants read contract. If we're confused about these first two, you probably need to come see me in the office hours. But we're in this judgment for a claim for $50,000. There's a judgment for $50,000. Now I, the plaintiff, am trying to collect that judgment. I need to obtain a garnishment order from the trial court, seize the bank account. Maybe I got to go match the commissioner or some of the fun procedural things that I have to do with collecting the judgment. The judgment's there. Can the defendant appeal now? Once the judgment for $50,000 is entered, the defendant appeal. Doesn't have to wait until after the garnishment. Are there any claims remaining to be adjudicated against any defendant? Or has the substance of all claims been decided? Who says it can be appealed now? Who says you gotta wait? Nobody good. Yes, that's appealable now. Appealable now. All the collection stuff, that happens separate. It's a different universe, right? Separate that from the idea of a finality of work. The court decides, you win on this claim. You win. The mechanics of collecting, we don't care about that. The interesting thing about that one, the trial court retains limited jurisdiction for you to be able to collect a judgment. Right? If the defendant appeals that, can plaintiff still collect while it's on appeal? You think the plaintiff can still get this $50,000 even though the defendant filed an appeal? Not even cares. It's just fun. What? No. The answer is yes. You can continue to collect the judgment, but the defendant would have the opportunity to pay what's called a supersedious bond, pay a bond on appeal, in order to keep you from collecting the judgment during the defendant's litigation. Okay? But interest is still going. Number two, plaintiff sues two defendants for negligence. Covered this. Trial judge grants the first defendant's motion to dismiss the case against the client personal jurisdiction. Is dismissal of the case a final judgment under 28 U.S.C. 1. Is that a final judgment? See a mixed bag of responses here. Yeah.
You didn't get much business in.
Are there any claims left to be adjudicated against any defendant? Yeah.
So it's not
Probably not a final order. Probably not a final order. Right? Now, is it possible for a judge to say, this is sufficiently different from the second defendant's case, so why don't you go ahead and take your appeal now? Yeah, it's possible. Right? But it's unlikely. Generally speaking, I don't want you to think about that as being a final order. Six is fine. Plaintiff sues defendant for unfair competition. Plaintiff asks the defendant to disclose the consequences. Defendant says no, that this is a trade secret, asks the court for a protective order, or grants the protective order. And the plaintiff appeal grants the protective order. Run to the appellate court and say, this is a protective order entered in a discovery matter, and I don't like it. I don't like the appellate court to review it. Go ahead.
I would say, so on the fact where I don't know if we can equate that to being an injunctive.
I wouldn't.
So then it would, you can like file it under that. This isn't that we can
Yep.
This is
Yeah, no, that's right. This is not a 1292A. No.
I mean, it's possible that you can get the trial judge to read it and then the court judge can review it.
It's possible, but extremely unlikely. Extremely
So I
unlikely.
mean, yes, so technically yes, it could, but there are not going to get results.
What would be the procedural device that you'd be most likely to run to the Court of Appeals with if you really want them to review this? I don't think it's 1292B. I think that is for something that really could affect the affirmative rights one way or the other. So in other words, if this is an issue that, like the First Amendment example, like if this is an illegal issue that would dispose of the case altogether, then you're talking about 1292B. Right? Protective order really isn't that. If you really want to get the Court of Appeals involved, you have what? I think a writ of prohibition. Right? Prohibiting the lower court from implementing its protective order. But it's not appealable. You don't get to appeal that word. That's an interlocutory word. You don't get to appeal. It's just a discovery. So if a judge rules against you in a civil case on a discovery matter, as they will come as you do not get to go and appeal that word. You're going to have to use some other arcane procedural device, and it's probably going to fail. Again, you can't screw up these notices of appeal. Okay, so look at 7303. 7303, state rule says the notice of appeal shall specify by name all accounts at least. It tells you specifically that et al. And et cetera. Even if that's what you've been using for the last 2 years in the trial court litigation. For all your pleadings, you don't get to say et al. Or et cetera in your notice of appeal. You have to specifically spell out every single person that's involved in the appeal. And you identify the judgment that's being appealed from. That seems simple, but do practitioners screw it up? Sure they do. As you saw, hopefully, in the Morris case. What happens in the Morris case? Morris versus Cabinet for Health and Human Services. Come on. What was the mistake the district council made in the Morris? Yeah.
So it was a donation for legal rights case, and they didn't notice that since the child didn't matter, but they just listed the child's name on the claim. They did serve the child was out minor, so that's what they said it was okay. They didn't list out the child, had it.
In fact, they did, right? In fact, they did. It's just not in the style of the case in the notice of appeal, right? It didn't list the child. Some poor lawyer had to have a heart attack for a couple of years over that. All this got worked out by the Kentucky Supreme Court. The Court of Appeal says, yeah, I mean, that's fatal to your entire appeal. Keep it clear to everybody what this appeal is about, who's involved, violating the letter, according to the Court of Appeals in this case, violating the letter of CR 7303 was enough to dismiss the entire appeal. The Supreme Court stated it. But where you often see this come up is in attorney's fees cases. So, this is a weird one. If you litigate a case all the way through to the end, and the statute gives you your attorney's fees, you get those attorney's fees from the court. And that all becomes part of your final judgment. The other side says, no, I don't like that final judgment. I especially don't like the attorney's fee award, so I'm going to appeal it. And if you don't name the attorneys on the other side in the appeal, in the notice of appeal, they're not parties to the appeal, and you don't get to appeal the attorney's fee. That's where you see practitioners before this one. All right, look. Draft me a notice of appeal. Show me that you can do this. Right? Simple. So 1 page. In groups of 5. 1 page, maybe 2 pages on your notice of appeal. You're the plaintiff. The judge has entered 2 separate orders dismissing the defendants. Assume, I'm not trying to trick you here. Assume this last 1018 order is the final order. It's a final judgment. Okay? Assume that the appellate court can take jurisdiction right now. Draft me a notice of appeal. Don't screw it up.